Case number Regional Court 44620B, State versus Julius Malema, Gerardus Snyman. The date is the 1st of October 2025. The parties is the same as yesterday, with the presiding officer, Mr. Steve Olivier, Public Prosecutor Advocate J. Caesar, Defense Advocate L. Rhodes, SC on behalf of accused number 1, Advocate S. Matthews on behalf of accused number 2, interpreters Ms. Murray, Clark, Ms. Kameli. The issue of this matter was set down today for further judgment to be delivered. We just request that all cell phones be switched off or on silent before the judgment continues.
But I need to quote this and have all the arrangements after you get my
Yes, no, not at all. It's why as I said, I attempted to reduce and extract and do curtail proceedings for that time. So I'll do as fast as I can.
The airplane unfortunately left us, so we're going on by the plane.
The court will now deal, as I stated yesterday, with the heads of argument presented by Advocate Caesar. Thereafter, Advocate Rhodes and Advocate Matthews. I will summarize as follows. The court does not deem it necessary to read out all three written heads on the merits of the matter. It was done so by the state and the defense and read out into the record. Therefore, the court will note the following aspects as reasons for the application for conviction and the application for acquittal. These reports in essence amounted to plus minus 130 pages, which I have reduced to 3. So let's go. Advocate Caesar, in summary, the state applied accused 1 to be convicted to all charges placed on record. Further, that the state has managed to prove its case beyond reasonable doubt, and that the firearm depicted in the footage presented before court was indeed a real firearm, and that the version, for the reasons mentioned in the state's head of argument, that accused 1 be convicted as charged. The evidence presented by the state Viva Bonke is supported by documentary evidence with regards to the accused. The state, with regards to accused 2, the state submits that the state did not prove its case beyond reasonable doubt, whether accused 2 handed the SPA 24914 rifle to accused 1, and therefore applied that accused 2 be found guilty to an accessory after the fact. I'm not going to dwell on that application. Advocate Rhodes addressed the court on merits, and in essence provides the following factors or reasons as to why accused 1 should be acquitted and found not guilty to all counts. Firstly, that the evidence of Colonel Swartboy is a clear indication of the deficiencies in the state's case, and that he deposed of 23 statements. Further, that there was no connection or match between the firearm by means of DNA and fingerprints that links accused 1 in any manner. No eyewitness had complained about any conduct during the time of the celebration. The photographer of the viral footage had not been traced, and further that it cannot be disputed that a TV or blank gun emits muzzle flash. There is also no evidence of a 9mm Glock handgun or evidence regarding the ammunition thereof, and no spent cartridges were found at the stadium of the above caliber, and it was also not placed before any witness that a 9mm Glock was also used at the event. No attempt was made to obtain a statement from Larry Mavunda, and further that there are no witnesses to the effect that any 9mm caliber cartridges were picked up at the stadium. Further, as per Exhibit A before court, it gives a clear indication of the structure and the stage, including the tents. Therefore, it is clear that if shots were fired, damage would have occurred. And per the evidence, no damage was detected. Also, that there is no proof that the cartridge that was handed in was actually fired on 28 July 2018. And with regards to video footage provided by Gia's company, the laptop used on the night in question has subsequently been stolen. As far as the viral footage is concerned, it was argued that it was not authenticated. The spent cartridge cannot be linked to where accused 1 was on the stage at the celebration, and the suspected firearm cannot be linked to accused 1, including the spent cartridge. No person reacted in fear. The 5 VIP SAPS members did not witness any shooting. No evidence of any physical damage was placed before court, and therefore the defense supplies that accused 1 be acquitted to all counts. Heads of argument by Advocate Matthews on behalf of accused 2. Firstly, there is no statement before court that states accused 2 handed a firearm to accused 1, and the state conceded that there is no evidence that accused 2 handed the firearm to accused 1, nor is there any evidence that he supplied or gave possession of any such firearm to accused 1. Accused 2 had provided the court with the Section 115, subsection 1, Act 51 of 1977 statement, wherein he stated that I place all the elements of the offences in dispute and specifically deny handing a firearm or ammunition to Mr. Malema at any stage. And Advocate Matthews had then stipulated the factors mentioned in the further particulars by the state, which the court had placed on record. It is also submitted by Advocate Matthews that he agrees with the state's submission that if one observes the clips, accused 2 was unaware of any shots that might have been fired. The state also conceded that it is bound by the further particulars provided to the defense by the state. The firearm in question was not in East London on the day in question, and that Larry Mavunda was called by tactical security services from Gauteng to Durban, where he had handed the CN SPA 249-14, including a 9mm Glock firearm, presented it to Colonel Janssen. It was not taken by Colonel Janssen, but I will get to it. Further, that the so-called viral footage was not proved as the original device and was never traced or produced in court. The second video footage, being the Gia's company footage, it was highlighted by Advocate Matthews that the video footage revolves around it being ruled or deemed as real evidence or as documentary evidence, and that the distinction between the two is of great importance. Real evidence only requires relevance, the other requires originality and authenticity before it may be ruled as admissible. In essence, that there is no evidence before court that accused 2 committed any of the alleged offences, and read in the light of the state's concession in this regard, apply that accused 2 be acquitted to all counts. I'm not going to deal with the address regarding the application for a necessary alternate. Therefore, the court will now, as it is obliged to do so, deal with the law applicable in any matter, not just the matter before court, that any court must consider and place on the record the law and what is required of the court to do in arriving at a just decision. It is well known in a criminal matter that the burden rests on the state to prove the guilt of an accused beyond reasonable doubt, no more and no less. This is clearly stated in State v. Jackson, 1998, 1 SACR 470, Supreme Court of Appeal Act 476. It is further required that the court must consider all the evidence, and I'm saying all the evidence, hence it took 2 days to place all the evidence on record, to arrive at the factual basis determined by evaluating all the probative material admitted during the course of the trial. The case law stated in Stellenbosch Farmers Winery Group Limited versus Mattel ET and others 2003 1 SA 11 Supreme Court of Appeal decision is clearly outlined and thereafter followed by numerous decisions up to date. And therefore, to come to a conclusion on the disputed issues, the court must make findings on the credibility of the various factual witnesses, their reliability, and also the probabilities of each case. Findings regarding credibility of a witness, namely the veracity of the witness demeanor, in the view of the court, not as important whilst in the witness box. Any bias, latent and blatant, and internal contradiction in his evidence. It further requires an analysis and evaluation of the probabilities or improbability of each party's version on each of the disputed issues. Once having done so, the court is required to determine whether the party burdened with the onus of proof has succeeded in discharging it. It is therefore the correct approach to weigh up all the elements which points toward the guilt of the accused against all those which are indicative of his innocence, taking proper account of inherent strengths and weaknesses, probabilities and improbabilities on both sides, and having done so, to decide whether the balance weighs so heavily in favor of the state as to exclude any reasonable doubt to the accused guilt. In State v. Sabana and another 1992 1 SASV 199 Appellate Division, I should also add, it's not old, it is a case law. This dictum in Sabana has been followed in judgments and by courts up to date. With the versions of the state and the defense are contradictory, the relative honesty of the two conflicting versions is indeed of great importance. Before, however, a finding as to the objective truth of the version and the falsity of the other can be reached, not only the honesty of the version is to be considered, but also and more particularly the reliability thereof. What has to be proved is the truth of the owner's bearer's version, and not merely the honesty of the witnesses who put it forward. Honesty and objective reliability are not synonymous. It has been stated in various case law matters that proof beyond reasonable doubt does not equate to proof beyond a shadow of doubt. If a remote possibility in his favor, which can be dismissed with a sentence, I quote, "Of course it is possible, but not in the least probable," unquote, the case is proved beyond reasonable doubt. Reference is made to State v. Kadebe, 1991, to SACR 166, a then Transvaal decision, deals extensively with the burden of proof. The test remains whether there is a reasonable possibility that the accused version or evidence may be true. In applying that test, one must also remember that the court does not have to believe his or her story. It is sufficient if it thinks there is a reasonable possibility that it may be substantially true. The case law is clear that no onus rests on the accused to convince the court of the truth or any explanation he or she might give. If he gives an explanation, even if that explanation be improbable, the court is not entitled to convict unless it is satisfied not only that the explanation is improbable, but that beyond any reasonable doubt it is false. If there is any reasonable possibility of his explanation being true, then he is entitled to his acquittal. I repeat that in all the case law pertaining to reasonable doubt, the one common denominator remains that beyond any reasonable doubt cannot be precisely defined. but it can be said that it is a doubt which exists because of probabilities or possibilities which are considered reasonable on the grounds of general human experience and knowledge, and therefore it does not equate to proof beyond the slightest doubt. The court does not have to be convinced that every detail of an accused version is true. If the accused version is reasonably possibly true in substance, the court must decide the matter on the acceptance of that version. Of course, it is permissible to test the accused version against the inherent probabilities, but it cannot be rejected merely because it is improbable. It can only be rejected on the basis of inherent probabilities if it can be said to be so improbable that it cannot reasonably possibly be true. It also remains a fact that there will need to be an evidential basis for suggesting that the evidence of a specific witness may be unreliable. An evidential basis does not include mere suggestions by cross-examining counsel. The issues pertaining to the matter before the court that needs to be addressed is firstly, I will deal with the evaluation of police statements. This is relevant in the matter with regards to as far as it pertains to Captain Governor, Colonel Zuko, where cross-examination was extensive, and the following law is cited in this matter and followed to date. In Malafadiso vs. S 2003-1 SACR 583, Supreme Court of Appeal 593 to 604, stated clearly that a discrepancy in a statement caused by one sentence only could be interpreted in one of two ways. It must be read in the context of the whole statement. In this instance, I add it must be read in the context of the question or the statement posed prior to the witness answering. Therefore, the court must ascertain what the witness meant to say in order to determine whether there was a discrepancy and the extent of the discrepancy. This evaluation includes the circumstances in which the versions were given, reasons for the discrepancies, the effect of the discrepancies on the witness's credibility, and whether the witness has sufficient opportunity to explain the discrepancies. Lastly, the witness statement to the police must be weighed up against the witness's viva voce evidence in court. In State v. Pitto 2005, 1 SACR 971, the court should determine whether he or she was satisfied, and this is also important in this matter, that the court is obliged to determine whether the witness was satisfied with the correctness of the contents of the statements as far as it pertains to previous statements to the police. Evaluation of contradictions. I will deal with that concept. Contradictions per se do not lead to the rejection of a witness's evidence. They may simply be indicative of an error, and the law is clear that not every error made by a witness affects the credibility. In each case, the trier of fact has to take into account such matters as the nature of the contradictions, their number and importance, and their bearing on other parts of the witness's evidence. No fault can be found with the conclusion that what inconsistencies and differences there were of a relatively minor nature and the sort of thing to be expected from honest but imperfect recollection, observation and reconstruction. One may add that such contradiction points away from the conspiracy which may be relied on. It is also a well-known concept in our law that where a witness has been tied down by repeated cross-examination to make estimates for an example with regards to times, etc., and in the process contradicted himself, it may be a misdirection to attach much importance to those contradictions when elicited by counsel and results in concessions made to ensure that it indeed comes to an end. at Hotep Jones Treasure Architect CC versus University of Fort Hare 2002 5 SA 32, an ECD decision, states that a concession, like any other evidence, may either be conclusive or count for nothing. Witnesses make concessions for any number of reasons, sometimes because the concession is in fact warranted, sometimes because they are confused or tired, or because they do not understand the effect of the concession, sometimes in circumstances where they are asked to attach their interpretation on certain events. The concession, like any other viva voce evidence, must be weighed by the court in the light of the totality of the evidence before it and the probabilities revealed thereby. This matter also requires the assessment of corroboration by court. The leading case law, in my view, still remains State v. Gentle, 2005, 1 SACR 420 SCA decision at 430. It must be emphasized that by corroboration, it refers to other evidence which supports the evidence of the complainant and which renders the evidence of the accused person less probable on the issues in dispute. What is required is credible evidence which renders the state's version more likely and the accused version less likely. In State v. Van Aswegen 2001 2 SACR 92 SCA decision 101 D-E, the following approach was cited and adopted in State v. Van der Meijden 1999 1 SACR 447 at W, close bracket. The proper test is that an accused is bound to be convicted if the evidence establishes his guilt beyond reasonable doubt, and the logical corollary is that he must be acquitted if it is reasonably possible that he might be innocent. The process of reasoning which is appropriate to the application of that test in any particular case will depend on the nature of the evidence which the court has before it. What must be borne in mind, however, is that the conclusion which is reached must account for all the evidence. Some of the evidence may be found to be false, some might be found to be unreliable, some might be found to be only possibly false or unreliable, but none of it may simply be ignored. In this regard, also see State v. Crossburg, 2018, SACR 317, Supreme Court of Appeal at 157. It has been stressed in various case law that the importance of the principle that evidence must be assessed holistically is also noted by this court. The matter also warrants reference to State v. Traynor, 2003, 1 SACR 35, SCA decision, paragraph 9. A conspectus of all the evidence is required. Evidence that is reliable should be weighed alongside such evidence as may be found to be false. Independently verifiable evidence, if any, should be weighed to see if it supports any of the evidence tendered. In considering whether evidence is reliable, the quality of that evidence must of necessity be evaluated, as must be corroborated. It must be therefore corroborated evidence, if any. Evidence, of course, must be evaluated against the onus on any particular issue or in respect of the case in its entirety. It should also be noted that the high standard of proof universally required in civilized systems of criminal justice is a core component of the fundamental right that every person enjoys under the Constitution to a fair trial. It is an inevitable consequence of living in a society in which the freedom and the dignity of individuals are properly protected and also respected. Therefore, convictions based on suspicion or speculation is not permitted. The court also needs to mention the chain of custody, being the document of activities, or explained as being the document of activities performed on digital evidence by recording its control, transfer, analysis, and disposition during criminal cases. It is crucial to maintain a complete chain of custody report to ensure that evidence is not compromised at any point from the time of collection to its court presentation. It shows who has collected and accessed digital evidence when the evidence was transferred. Typically, a chain of custody report must include the following information to maintain a detailed log of activities performed on digital evidence: the name of the investigator or police officer who collected the evidence, the time and date when the changes have been done in the evidence, description of evidence, relevant serial numbers or case numbers, activities performed on the evidence such as evidence has been uploaded and viewed. There is no need to say that digital evidence is a key element in solving criminal matters. In order to prove the guilt of an individual or not, prosecutors must therefore justify that the evidence presented in the court is as original as collected at the crime scene. Therefore, the chain of custody is more important than digital evidence itself, as it proves the integrity of evidence in court. What is required is a detailed log of activities performed on each evidence file through a comprehensive chain of custody report. A further aspect that the court needs to place on record pertains to the evaluation of expert witness testimony, and I emphasize the requirements. The court must be of the opinion that the person is an expert and competent to testify as an expert. The expert testimony must comply with 3 basic requirements: the basis for the expertise and the expert's qualifications, experience and expertise, and specifically knowledge must be put before the court. The basis for the opinion and reasons for the opinion must be put before court, which was used or which was based on the facts in the case. The opinion of an expert must not displace that of the court. The prime function of an expert is to guide the court to a correct decision on questions falling within the expert's specialized field. Engelbrecht 2005 to SACR 41 in brackets WLD bracket. It cites that courts frequently turn to